I want to tackle is the Mueller investigation. We're told that this is the 1-year anniversary. What are we supposed to do? Have a cake? Light candles? I don't know. 1-year anniversary. Is this a national holiday? It's a disgrace that this has gone on for 1 year. He hires these enormously aggressive, irresponsible, and in some cases unethical prosecutors, most of whom are active Democrat donors and supporters of Obama, Hillary, or both. And what charges have they brought? They're just beating the hell out of Manafort. Now his ex-son-in-law is turning on Manafort, trying to get the former campaign chairman to buckle under any circumstance, do anything he can just to get him to give him Trump somehow, some way, somewhere. Does that sound like justice to you? He's taken down Lieutenant General Michael Flynn. An outrageous attack on Flynn. Does that sound like justice to you? He's rounded up plea agreements that any assistant district attorney in some town with 12 people could do. Oh, look at that, a false statement. Charge him, charge him, charge him. This is a failed, disastrous prosecution team. I'll be right back. It's time to give your bathroom the cleaning it deserves. Get rid of all the junk that's lying around. Freshen it up with high-quality products from Dollar Shave Club. Dollar Shave Club delivers everything you need to look, smell, and feel your best. Razors, shave butter, shampoo, body wash, toothpaste, everything. I get an amazing high-quality shave using my Dollar Shave Club Executive Razor. And their Dr. Carver's shave butter is fantastic. It goes on clear so you can see where you're shaving. And since DSC delivers everything to you, you don't have to set foot in a store wandering the aisles, hunting for razors, shampoo, body wash, toothpaste. None of it. Clean up your bathroom and your morning routine. Join Dollar Shave Club today, and for just $5 with free shipping, you'll get the 6-blade executive razor plus trial sizes of shave butter and body cleanser. Then keep the blades coming for a few bucks more a month. Get yours at dollarshaveclub.com/Mark. That's dollarshaveclub.com/Mark.
He's here. He's here. Now, broadcasting from the underground command post, deep in the bowels of a hidden bunker, somewhere under the brick and steel of a nondescript building, we've once again made contact with our leader, Mark Levin.
Hello, everybody. Mark Levin here. Our number, 877-381-3811, 877-381-3811. Other things I want to get to, but I want to finish this as well. Reminder, I'll be on Hannity on Fox, 9:30 p.m. Eastern Time tonight. I was watching the various lawyers, professors, associate professors, assistant professors, former prosecutors, defense counsel, the long conga line of known and unknown lawyers on cable news who fill up time. Most of them, and when you're not constitutional lawyers, and most of them have never dealt with independent counsel, let alone special counsel. It's a different animal. It's a different animal than a U.S. attorney's office. It's a different animal than federal prosecutors that work out of Maine Justice. It's a different animal than in county prosecutors' offices or district attorneys' offices. It's a completely different animal. And when you're investigating a president of the United States, there are different terms. He is the most prominent person in our constitutional system. This isn't an embezzlement case. It's not a corrupt mayor case. It's not a case about a congressman stealing stamps or a judge taking a table. All of those are serious cases. The circumstances involving the President of the United States are completely different than involving anybody else. And what the Department of Justice had concluded is that you cannot indict a sitting president. I didn't make that up. I dug it up. First, I found a 1973 memorandum written by the Office of Legal Counsel, which is the office that essentially oversees the constitutional issues relative to an administration, as well as, of course, the Department of Justice. And I read it. And it was a very detailed, comprehensive, dense listing of precedents, of court cases, and historical facts pulled together in a very rational manner. And I kept digging, which is what I do, and I found another one. October 16, 2000. And that particular memorandum was reviewing the 1973 memorandum. So you had the Clinton administration reviewing the Nixon administration memorandum. And that latest memorandum from 2000 agreed with the memorandum of 1973, I would say 98.9%. There were some newer cases, more case law to look at, particularly given the Clinton litigation involved on the civil side, not on the criminal side. And they drew the same conclusions for many reasons. For many reasons. A senator is one of 100. A congressman is one of 435. A judge is one of almost 1,000. The country can do just fine without 1, 2, 3, 5 of them. And so, you look at the framers and how they debated the issue of impeachment. Where did they get this whole idea from? Where did they come up with the idea of impeachment? They didn't invent it. Through English common law, going back to the 1300s. And they didn't particularly like all aspects of what they saw in English common law. So they debated it. They debated the language. They debated how it should be applied. They borrowed some of it from the practices of the Parliament and the monarchy in Britain, and they creatively modified some of it for our constitutional system. They kept the part where the House of Commons, in our case the Congress, would bring the charges, and the House of Lords, in their case our Senate, would handle the trial. They also decided that the Senate should not be able to remove a president by a simple majority, even though the House could impeach a president by a simple majority. An impeachment is an indictment. Not a criminal indictment, a constitutional indictment. The reason they didn't go with a simple majority in the Senate, and they tell you why. They didn't want the Senate to be able to hold sway over a president. They didn't want the Senate to be able to blackmail a president. They wanted some ability to hold a president responsible, but they didn't want the ability of another branch to lord over the president. And so they came up with two-thirds. Two-thirds. The language, high crimes and misdemeanors, have absolutely nothing to do with criminal law, and they make that abundantly clear. High crimes and misdemeanors. What the British had called it was high misdemeanors. And they debated what that meant. High crimes, they decided, were not actual crimes, but offenses against the body politic, offenses against society, offenses that are so significant that they merit, charges and a trial. High crimes and misdemeanors. So they broke up the phrase high misdemeanors. It's not like, you might say, I got a misdemeanor because I jaywalked. It has nothing to do with that. Nothing whatsoever. And, of course, there's other language in there as well. And mostly, during the Constitutional Convention, they focused on the presidency. There's no discussion about judges whatsoever. High officials are subject to impeachment, but their focus was on the presidency. And one of the things they said was, interestingly, that, of course, if a president is impeached and then removed by the Senate, therefore he's a private citizen, or she is, he or she is subject to the usual criminal justice system. Charges and so forth, and trial and so forth. So they said after impeachment and conviction, subject to criminal prosecution, indictment. The fact that they explained it that way, they debated it that way, and settled on it that way, more than infers, more than implies that they didn't expect a sitting president to be indicted. Moreover, the impeachment process itself requires the participation of the body politic. The House of Representatives, closest to the people, they felt. Elections, every one of them, every 2 years. The House brings the charges. Now, why did they say the House brings the charges? Because you're talking about an individual who's president of the United States that is elected by the entire country through the Electoral College, but nonetheless, the entire country votes. For the president and the vice president, those are the only public officials where the entire country votes for them. And they are in charge of the entire executive branch of the government. So they would never even dream of thinking that a prosecutor and a jury would have the power in lieu of the House of Representatives and the Senate, that is, these two bodies of the people, to effectively remove a president of the United States. Nor would they in any way contemplate that a prosecutor and a jury would have the power to cripple the president of the United States. The president had specific powers under Article 2, very significant powers under Article 2. The idea that a prosecutor and a jury of 12, back then it could be a jury less than 12, but a jury of 12 could have the power to nullify, in essence, the impeachment clause, would have been absurd. And it is absurd. Another point. When you look at our Constitution, there's some very interesting things in there that are intended to protect the individual, particularly in cases where they're being accused of criminal conduct. We have due process, probable cause for warrants, the right to a speedy trial, jury trials, all this process in place to protect the individual who's charged by what? The government. Because liberty is precious. If you're president of the United States, argued the Department of Justice in both memorandum, that means you're not going to be able to protect yourself, to defend yourself to the fullest extent of the Constitution under the procedures provided in the Constitution as a citizen, not president of the United States, would be able to do, because you're also focused on your myriad heavy responsibilities as president of the United States. So people say you're not above the law. Well, if you're able to indict a president, the president will not have the capacity to provide the kind of attention an individual needs to apply if they want to stay out of prison. And of course, what is the ultimate purpose of indicting somebody? Well, to try them, but that's not the ultimate purpose. To convict them, that's not even the ultimate purpose. To imprison them, that's the ultimate purpose. And it's obvious that you can't have a president of the United States functioning behind bars. Now, you might say, well, there's the 25th Amendment. There was no 25th Amendment when the Constitution was adopted. There were no amendments. The Bill of Rights would come first from the first Congress and then obviously through the ratification process in the states. There was no 25th Amendment. They never ever contemplated the ability to remove a president this way. And a prosecutor cannot then seize the 25th Amendment as a way to remove a president. That's not what the 25th Amendment is there for. Moreover, the people of the United States didn't elect the vice president as president of the United States. The only reason the president is incapacitated under a circumstance of the kind we're talking about is because a prosecutor has created the circumstance of incapacitation. Nothing physical, nothing mental, nothing of that sort. That's another reason you don't indict a sitting president of the United States. Furthermore, what the memoranda do not discuss, if a special counsel can indict a sitting president of the United States, what is to stop any of the 93 United States attorneys from indicting a sitting president of the United States? Well, you might say the Justice Department. No, not the Justice Department, because the Justice Department has already said you cannot indict a sitting president of the United States. So if Mueller does it, he's defying his own department. He's defying his own bosses, which is why he won't do it, I don't believe. But that said, just think it out. Just like form shopping with these left-wing judges. Let's say there's a U.S. attorney who really wants to earn credentials, and he's not happy with what the president's doing, or she's not happy, and they find some cockamamie argument, some cockamamie way to pull together a grand jury. Let's say the president has an investment in that state. You've seen these attorneys general throughout the state, like the Schneiderman, that pervert. By the way, do you have to be a pervert to be Attorney General of New York? I think that's the one main credential. But anyway, so you can see how easily you can begin to destroy the Constitution, the Republic, and the office of the presidency. And the office of the presidency. These are not necessarily my positions, ladies and gentlemen, although over the years I've become more and more sympathetic to them. But these are the positions of the United States Department of Justice. I've embellished a few points because they didn't have them, and I'm adding them. And so I circle back when we had this debate about subpoenaing the President of the United States and Professor Dershowitz, who I like. I've met him once or twice, but people go, you hear what Dershowitz said? Professor Dershowitz said, look, if they subpoena the President of the United States, he's kind of stuck. What can he do other than plead the Fifth? He's got to negotiate with Mueller. I said, BS. He doesn't have to negotiate with anybody. He can say no. Because ultimately, you're trying to subpoena and bring him in front of a federal grand jury. And he could say, no, you cannot bring me in front of a federal grand jury to ask me these cockamamie questions for the purpose of entrapping me and indicting me. You want me to answer questions, they have to be very finely tailored, and I'll decide if I want to answer them or not in the manner and form that I choose to answer them. And when you looked at the 49 categories of questions and areas that Mueller was looking at, they were preposterous. The president doesn't have to submit to that. And so I started talking about this, what the Department of Justice's position is. And Mr. Mueller, when he got his appointment, I went back and looked at that. And Mr. Mueller's appointment says he must comply with, I'm paraphrasing, the policies of the United States Department of Justice. And the policy in this case is no indict. No indict. And I've said that on the air too. This apparently has now become the official position of President Trump and his lawyers. It wasn't before. And apparently, if Rudy Giuliani is correct in his relaying of information to us, it apparently is the position of Mr. Mueller, even though I don't trust him. We'll be right back.
Mark Levin.
Rudy Giuliani on Fox and Friends. Cut 6, Mr. Producer. Go.
I asked them specifically if they realized or acknowledged they didn't have the power to indict, both under the Justice Department memo, which gives them their power, in essence, confines their power, and under the Constitution. And he said, well, he wouldn't answer. And one of his assistants said they acknowledged they had to be bound by Justice Department policies. And then the next day or the day after, they clarified it for Jay Sekulow, who was with me at the meeting, that they didn't have the power to indict, that what they would eventually do is write a memorandum and give it to the Deputy Attorney General, Rosenstein. And we never got to the issue of subpoena. I think he had raised that earlier with John Dowd, but it didn't come up with me. But we're pretty comfortable that in the circumstances of this case, they wouldn't be able to subpoena him personally.
And if they do, I mean, they physically can subpoena him personally, then the battle begins. Then the constitutional battle begins. This has not been the position of the Trump lawyers. It is now. I hope it is, and I'm quite gratified